Hello and welcome to this video on applying the law. Now it's going to be focused on AQA scenarios. It is strategy that possibly could be used for others, but this is based on my teaching. Just a quick note, it's not endorsed by AQA at all, but it's for A Level Law. Now it is based on scenario questions, so we're just going to look at how to approach them and hit all the correct bands when applying the law to problem-based questions. So to begin with, we're going to look at the different types of questions you're going to face in this exam. Now the structure remains the same for paper 1, 2 and 3 and both paper 3, the human rights and contract law papers. So we start off with 5 multi-choice questions, and those multi-choice questions are going to be a mix of substantive and non-substantive law, so usually focused on ELS. Question 6 is a 5-mark question, so that's an ELS question. There'll be other videos on that. But the 5-mark for question 7 is proving or disproving a statement. This is an application question. Question 8 has 10 marks. Again, this is a topic is guided or listed, so you might have to apply the relevant law. It could be defense, could be an offense, could be a tort, could be a contract issue. But usually it's just one issue when it's a large application. Question 9 is worth 15 marks, and this is a theory question. Again, there's no application here, but there is a link and analysis to a theory and an area of the law, which is linked to the paper. But the difficult questions, arguably, are questions 10 and question 11. Now, for question 10, I mean, they both work the same marks, both worth 30 marks, and the advice is always to start with these in the exam question when you start writing out. But for question 10, it's usually 3 or 4 legal issues. So we've got an offence or a tort or a defence, or even contract or human rights issues. Now, questions can be usually be approached in the same way as question 8. Once the topics are established, so you're doing a sort of long form application. You know, it could be murder plus defence plus another issue. But of course, it's 3 sort of 10 markers or 2 10 markers plus, you know, sort of broken down issues. But we need to make sure we remember it could be 3, could be 4 issues in that question, and we apply the law fully to them. Now for question 11, then this is similar to question 10, but 7 marks this time out for analysing an ELS or theory element. So you're looking at 23 marks for application there. And this means possibly 3 issues in addition to the 7 marks for ELS or theory, or 2 larger issues. So of course we need to analyse the question beforehand. So just a note on this video, then we're going to be doing questions 7, 8, 10 and 11. The skills we learn in this video are going to be based on those particular questions, and they can be used. It's a new strategy to try to help you to look through those. Now you may come across different methods if you have different law teachers, different guides and so on, and how to apply the law. You know, one traditional method I've used is the AQA principle, the idea of identifying the law, defining the law, explaining the law and applying the law, and then concluding. The problem with this is that E and A, sometimes you would need it interleave, and that can be a difficult skill to grasp, or when taught in isolation can be difficult. So this new strategy is sort of based around that concept, but changing the E and A little bit. You might also have ILAC or ISAS, you know, you will know that whatever you've been taught. But this can help, you know, even within those structures, because a new strategy, which I'm going to talk through, is just linked basically to the assessment criteria. So what I would suggest is we make our point, so whatever the legal point is, we link it to the scenario by applying it, but always focus on analysing the law. Now there's many different ways of doing this, and what we're going to do in this video is discuss each of those points. Now of course, I mentioned before, you know, I traditionally taught the IDIAC structure, and of course you need to identify the law and define the law to an extent. So you do need to introduce the legal issue like in the other strategies, but don't spend too much time on it. Okay, so if you've identified the legal issue, so for example it could be negligence on paper 2, murder on paper 1, or consumer rights issues on paper 3, then state what the issue is and outline the elements required. So almost making that list. It helps in terms of structure too, because if you keep referring back to that sort of list of things that is necessary to be proven, then you can sort of keep your time management better. You can make sure you answer the full question by completing all of those elements. Now, of course, don't spend too much time defining the legal issue either. So if you've outlined the issues, that's usually enough. But of course, you know, if your time management is good, if you tend to be getting, you know, A's, A stars, or even B's in exam questions in class, then you probably can still use the full definition. You know, obviously the answer will be better with it. But if there's anything you should cut out, then it should be that long-winded introduction. So, for example, you could use Section 1 of the Theft Act tells us what the theft is, and then give the definition, or the Blythe and Birmingham Waterworks definition, well, the definition of negligence from that case. So, of course, you should issue and outline the legal issue, but of course, don't spend too much time with that definition. What you're focused on is, of course, applying the law and analysing the law and explaining in enough depth the law. Okay, so when using this structure, the structure we're going to go to the PAA method. It's important to remember that it's cyclical. So the PAA is for each individual issue. So how many times this PAA pattern is repeated depends on how many elements the tort or offence or defence or legal issue has. So for example, if you've got negligence, then you should really be looking at sort of 6 PAA paragraphs. For ease, these could form each paragraph, in terms of structuring your work, it could help. So if we outline negligence as a problem in our question, let's say it's a question 8, it tells you, great, you can do that, but it could, of course, come up in any other factor. You've got the duty of care, you've got the breach, and breach 1, the reasonable person standard, breach 2, the risk factors, factual causation, legal causation, and then any potential defences. So we've got there is 6 PAA, so you would explain the legal point of duty of care, apply the point of duty of care, and of course analyse any elements. And again, we're going to come to how to do that shortly. But this means that this method then will work for shorter 5-mark questions, because I found in teaching these shorter questions, it's hard for the students to identify what to discuss. For 5 marks, it could be based only on legal causation, or based only on factual causation, or even acceptance in the problem question for contract law. And the students would sort of go through every single element that they know about that particular issue. So for causation, they would deal with each particular factor in that. So it's of course important to remember, use this PAA method for the issues that apply only, and that will help you in terms of applying the law more effectively. So I'm going to now discuss what I mean by each of these factors: so point, apply, and analyse. Obviously, we need to link it to the assessment objective. So assessment objective 1 is to demonstrate knowledge and understanding of the English legal system and legal rules and principles. That's a generic descriptor for AO1. And that is making the legal point, isn't it? Now, in an application question, that's worth around 30% of the total mark for the question, or portion of that question. We're dealing with things in isolation here. So if it was negligence, then 30% of the mark for negligence would be explained in the law. So usually what you're doing here is briefly outlining or explaining the element of the offence or defence or tort or other legal issue. For contract law, it could be the legal point in question. But this is, of course, driven by the facts of the scenario given. And it is also useful here, if you look at any mark scheme, then case law is useful here to explain the law as well. Now, be selective in what you do. You want to explain a case which supports your point. In terms of application, now this is probably, certainly in my experience, what students do well. Okay, so applying the legal rules and principles to given scenarios in order to present a legal argument using appropriate legal terminology. So what we got this is, this is, like I say, the students do well. They say how something is met in the scenario, but they may forget to do the AO1 and AO3 as well. Now that's a good thing in a sense, in that 40% of the total mark for the question or portion of the question comes from linking it to that scenario and, of course, concluding. So what you're doing here is explaining how the element is satisfied in that scenario, and of course link it to the facts given, and not forgetting to conclude. Analysis is something which I guess still generates some discussion, because if you look at the descriptor, it's analyse and evaluate legal rules, principles, concepts and issues. It's very broad, and there's 2 command words there. We've got analyse and evaluate. What I would argue is analyse is for the problem questions and AO3 for evaluate is elsewhere in the paper. So this would be, for example, in question 9, we have to evaluate a legal theory or concept, or in question 11, where you may have to evaluate or link to a particular ELS topic or concept for the 7 marks as well. So we'll split them up. What we're going to focus on is analysis when we're applying the law. Now, 30% of the mark comes from this. So what you're going to notice is this is easily accessible if you know how to do it. And of course, what you might be doing is getting that kind of 6, 7 marks out of 10 each time, because you're not doing this, even though there's nothing wrong with your answer in terms of explaining and applying. And indeed, in years gone by, that might have been acceptable in terms of a top level answer. But this analysis is necessary now, and so we need to get to grips with it. So what I would argue is this is extended application. It's not traditional evaluation. What you're doing is taking your answers somewhere else in order to hit that kind of higher criteria. So this also covers situations then where certain elements of the law need to be discussed, but others don't. So it could possibly be about what you don't include in addition to what you do include. And it also can include general discussion points. In terms of examples of how to reach that next level, how to analyse, it could be simple as raising an alternative point to the application. So you've got to present a balanced argument. On the one hand, this element may be met, but on the other, it might not be. Now, it doesn't mean you have to stop your application there. You can go forward to the end of the question and then eventually conclude as to whether you think there's liability, no liability, guilt, innocence, or what have you. But of course, it's that to the balanced argument, showing the examiner that you know both sides of the law here. You should remember to conclude as well, of course. Now, you could be considering hypothetical scenarios. So, for example, this would change if, but again, linking that to the scenario. It could be comparing the application points to previously decided cases. This is a really good one. Again, if you look at any mark scheme, case law is also in AO3 as well. So what the examiners are expecting is that this is something you do. You link it to a past case and say why it proves your point. Now, many of you might do that and not consider that analysis. And if you do, fantastic, because you will, of course, be hitting those grades by doing so. Now, discussing the AO1 point further as well, could be, AO3 as well, because you're taking the law and you're analysing it that bit further. So, if you're looking at causation, you could look at causation, discussing issues which would break the chain of causation, even if in that situation it might not have. Again, you're doing that, this would change if. Explaining the changes in the law, so, bad law, and why this is current or correct. So, if you're doing loss of control, it doesn't have to be sudden anymore. You can explain why that changed or how that's different from old law. If you look at negligence and duty of care, why the law's moved away from the Caparo and Dickman 3-part test, explaining why. Now, of course, you could have an evaluation point. What's good or bad about this part of the law? Though I would argue that's probably not as necessary as the previous points. Now, again, this isn't exhaustive. You might have been taught, you might have reading this, be inspired to do something different, or watching this video, that's fine. But of course, as long as you're doing something like this, then you're going to be okay. So as ever, we're going to do a worked example, just to show you what one looks like. Again, it's not perfect. This is taken from sort of, at least based on some students' work. So a basic scenario, again, adapted. We got from Mike was driving a pickup truck with a heavy load. When he secured the load, he'd been distracted by his children and had failed properly to tighten the straps on one side. Whilst negotiating a bend in the road near a school, the load suddenly shifted position and the truck overturned, crushing Jimmy, who had darted across the road without looking. Now Jimmy's arms and legs were broken in the crush. So if this was this is a very simple question 8, really. And we've got here, it's just applying the law of negligence to this. So it clearly would be negligence, and what we need to do is, before we start with the PAA method, is unpick the question. And so that's what we're going to do now. We're going to just unpick the question. The first thing we need to look at is the facts, right? So we've got, he's driving a pickup truck. So what you immediately doing is you're looking at what duty of care is owed. You might have picked that elsewhere. You might be, he's driving near the school. Does he owe a duty of care? You might pick that up as well there. He failed to properly tighten the straps on one side, so you could probably argue that's where your breach is. And then the truck overturned is just part of the event. You've got to consider, is that linked to the final issue of causation or the injuries caused? So that's the first thing we need to do. Obviously, make sure we're looking through the question. You can also annotate that further if you wish. I mean, this is a basic scenario, just for the purposes of this video. But you could annotate that to see, further really. So our introduction, quite simply, here the issue is negligence, and negligence is the omission to do something a reasonable man would do, or do something which a prudent a reasonable man would not do. This could be a murder scenario, and again, here the issue is murder, and then you get the definition of murder, necessarily, not necessarily the full definition, but that's something students do tend to remember. So once we've introduced it, now, of course, I'm just going to focus on one element here to demonstrate the PAA method. That's the purpose of this video. But what you're going to do is I'm going to walk through an example of applying the duty of care to the provided scenario. Now, there's a quick note here as well. I'm quite keen to make sure that we're not using the Caparo test. Okay, we need to be using the Robinson test. Now, it's a 2018 decision. It is fully integrated into our law now. Now, I'm just going to focus on duty of care. Obviously, that's, like I said, is cyclical. The PAA method should be done 6 times for a negligence question, in my opinion. You could do it a different way, of course, but that's just the way this video is going through. Now, you could try the other elements on your own. You could stop the video and you can have a go at them. Absolutely fine. But, of course, you could use this as a guide as well. So, I mentioned before, our point, demonstrating the knowledge and understanding of the ELS and legal rules and principles. What we're going to do here is, this is an example of how to do a point. So, relating to that scenario, firstly, a duty of care must be established between Mike and Jimmy. Now, a duty of care can be established following Robinson and the Chief Constable of West Yorkshire Police if there's an existing statutory duty, an existing precedent, or if the case can be reasoned by analogy. Now, you could take that further and say if it's a novel case, then you would use the Caparo 3-part test, but we don't use that in A-level law. Once we got that, we would consider application. So in terms of application, how is it satisfied in this scenario? Well, in this case, we can reason by analogy using Nettleship and Weston. So in that, if a car driver owes a duty of care to a passenger, then a pickup truck driver would also owe a duty of care to other road users and pedestrians. So we've got a case there as well. We're linking it back to the facts, that's okay. But again, this is probably the newest part to you in terms of how you apply the law. So analysis, how are we getting this, the 30th% of extended application? Well, you could have done one of these issues. You could say this principle could extend to users of other vehicles, such as motorcycles and buses. That's probably weaker than the next two. You could suggest, however, that it may be more prudent to use the Road Traffic Act, which imposes a duty of care on road users to other road users and pedestrians, as this is more likely to be solid ground for imposing a duty. It might not be, but you're taking that a little further. A better one could even be, however, this could be considered too dissimilar on the facts. Remember the Nettleship and Weston was just driving with somebody in the passenger. Here, instead, we've got the issue here is fixing the load as opposed to ordinary road usage, and also hits a passenger. So you could say this is novel, potentially, and so the Caparo 3-part test may be needed in establishing a duty, and then you would go on to apply that test. But like I say, in terms of duties, we've seen in the past things like boat users being reasoned by analogy for car drivers. So you're probably going to have one which you can refer back to, but of course it's up to you to make that decision and keep practicing. But that's what we say. So in terms of what a completed PAA paragraph could be, it's just those 3 together, as you can see on the screen. So you can pause and read through again if necessary. But that's one paragraph. Okay, so you've done duty of care. You would then need to do this for breach twice, causation twice, and any defences as well. So it's up to you. You could take this, you could pause it, you could keep going with this question, or you could use this strategy to help you. Now, in terms of hitting all the criteria, it will help you hit all the criteria. So as long as you're getting that analysis in as well, and you're thinking, how can I extend my application? If you're not doing that, then it's going to be very difficult to get to those higher boundaries. I hope you take this on board, so make sure you get the PAA method every time. Just keep that cycling through, and of course apply it as many times as necessary. And good luck.